Good day, everyone. Welcome to this week's edition of Immigration Matters with Vissia Calderon, only here on Home Sweet Home. The question that we're going to answer today was sent in by a loving mother from the Philippines who was very distraught because she left behind her 18-year-old daughter in her home country because she admitted to smoking marijuana twice during her medical examination and her consular interview at the U.S. Embassy. She asks, "Hi, Attorney Calderon. My name is Joanne, and I'm a new immigrant in the United States. I was petitioned by my father, and it took us many years to finally come to the United States. My husband and I were able to get our visas, and we're now both here. But my 18-year-old daughter was denied her visa at the U.S. Embassy because when she did her medical in Manila, the doctor asked her if she had used drugs in the past. She said that out of curiosity, she has tried smoking marijuana twice. During her interview, the officer asked her if it was true that she had tried marijuana, and she said that she did, twice when she was only about 16 years old. The U.S. Embassy denied her visa on two grounds: that she had admitted to a crime involving moral turpitude, and that she had admitted to committing acts in violation of a law or regulation of the United States or of a foreign country relating to a controlled substance. We're devastated. What should we do?" Hello, Joanna. Thank you for your email. Let me begin by saying that drug-related offenses are dealt with strictly under U.S. immigration laws. If a person admits to or had been convicted of a drug-related offense, there is no waiver available, and that person will not be granted a visa except if the offense is for possession of marijuana 30 grams or less. So the first advice I tell my clients and their families: never do drugs. To answer your question about your daughter's case, however, we need to evaluate her case further and her alleged admission. Note that the denial is predicated on her having supposedly admitted to a crime involving moral turpitude or a drug-related offense. The first approach that I will take in a case like this is to ask, was there a valid admission in the first place? Because for an admission to be valid, there are certain requirements. First, the admitted conduct must constitute the essential elements of a crime in the jurisdiction where it happened. Second, the applicant for admission must have been provided with the definition of the essential elements of the crime before he admitted to something wrong. The third is, his admission must have been free and voluntary. Now let's go through all of these requirements and see if they apply to your daughter's case. First, is your daughter's act of smoking marijuana twice out of curiosity and without anything else, like an arrest? First, is your daughter's act of smoking marijuana twice out of curiosity and without anything else, like an arrest, conviction in court, or testing positive for drugs during a drug test, if this is considered a crime under the law of her country? I know that in some countries, like the Philippines, for example, they do not punish the mere act of smoking marijuana, and every country is different. If your daughter's action is not a crime under Philippine law, then we may have a shot at saying that she did not admit to committing a crime because there was no crime in the first place. The second requirement for an admission to be valid: your daughter must have been provided with the definition and essential elements of the crime before she admitted to the crime. Here, if the doctor and the consular officer failed to advise her of the definition of the crime of possession of marijuana or use of marijuana, any alleged admission she made related to that can be considered invalid. Third, the admission must be voluntary. The idea is that your daughter must not have been coerced to admit that she has or was committing a crime. Also, she should know what she is admitting to. In your facts, Jennifer, we can probably argue that voluntariness is not present because your daughter could not have freely and voluntarily admitted to something that she does not know. The second approach that we can probably take in a case like this is to apply for what we call the 212H waiver. This provision waives crimes involving moral turpitude in those instances when the applicant admitted to committing controlled substance violations if they only relate to a single offense of simple possession of 30 grams or less of marijuana. Here, we can show that Jennifer or her husband faced extreme hardship because of the denial of her daughter's visa and inability to immigrate to the United States. Hardship we can show through financial hardship, emotional, psychological, health, and other forms. The government will look at the totality of the circumstances, so the more hardship we can show, the better. To be sure, Jennifer, we will need to look at your circumstances closely and see if what we just discussed apply to you and your daughter. I suggest you seek the help of a reputable immigration attorney. To our dear viewers, if you have immigration questions, feel free to call us at 702-659-7899 or email us at homesweethome@vegaslifetv.us. I'll do my very best to answer them right here on Immigration Matters with Vissia Calderon. Thank you, and I look forward to seeing you again next week, same time, same channel. Attorney Vissia Calderon at your service.